Hi everyone. So I decided to make this hopefully very short video to at least convey to you what are the elements that I'm looking for in your trial memorandum, and hopefully this subject matter can also be useful in other subjects that you will take in the future. Now again, the source is from Brian Garner's Legal Writing in Plain English. So most of the topics there are sourced from that book. Now let us begin. Now, class, the first thing you have to remember is that when you write a trial memorandum, you're like writing a story. You have characters, you have facts, you have events, you have flow of events. But the difference here is you have to convince someone, and that someone is a judge. You convince the judge through the law, through the quality of your arguments. But at the same time, it is very helpful if you write your story in a very direct and clear manner, right? Because imagine the judge has to read a lot of things, then you have to capture his attention. That is that is something that you have to think about when you begin the writing process. When you plan your trial memorandum, think about that. That the judge is reading so many papers, how can your paper shine? How can your paper communicate and talk to the judge clearly, right? So, like in any other story, na siya beginning, middle, and end. Well, in this particular slide, there is an example here of a beginning. Now, in my instructions, I'm requiring you to write a preliminary statement. Mga 50 to 70 words. A preliminary statement is placed before the facts. It's really the first paragraph. And it's very important because mo na siya class ang mag-frame sa imong arguments sa judge. Mo nang first na basahon sa judge. And it is critical in how he approaches your paper. Unsa ang quality, unsa imong framing, unsa imong main argument, main issue sa imong kaso. Now I have an example here based on the book, and again you can see it's very concise. It ends with a question mark, and it also addresses it to the court. Oh, the court faces the following issue, and then it starts off with a legal provision, then there's a factual circumstance, and then it ends with a question. So you can also try to experiment with that. There's no like a strict standard on how a preliminary statement looks like, but it can look like that. Now, a middle is the body of your trial memorandum. Like any story, again, the body is where you put in the details. Now, in a trial memorandum, this is comprised of series of headings and subheadings. And you have also to consider class na matahi. Kanang mga headings, matahi niya ang reader padulong sa usa ka conclusion. No? And typically, what we do in the middle part is the the middle part is divided kung pila ka book issue. So, for example, if you present 3 issues, you have to organize your middle part into 3 sections, right? For example, issue nimo ang is he guilty? Is person A guilty? Then you have, and letter B, is he liable for damages? So, sa imong argument, sa imong second, sa imong middle part, nagiging kay section na that explains his criminal liability, and the second part is explaining his civil liability. So, do you get me? Issue, then answer. That's the middle part. So, I'm just gonna read it out. Like, you have to elaborate the legal premises embedded in the issue statement, and it's important that you elaborate on the factual points. Then you deal with counter arguments, and then you drive home the point with additional reasoning. I will touch more on that later on, pero again, in the middle, you have to start out with the legal premise, then the application, then the counter arguments. So tanaw ni mo mura gyapon siya clock method, no? You start with the legal principle and then the application. That's what you do. How about the end? Well, the closing is just a summary, a brief summing up of the arguments. You can be creative in a way that it It can be just a sentence, like bullet 1, bullet 2, bullet 3. I did that in my demur to evidence, where the closing is an enumeration of summarized points. Like, he is not guilty because the paper is not, etc., etc. So try to make it very simple. The next second principle I want to show is this, the deep method, the deep issue method rather. Kaning deep issue method, it simply says that you want to put the issue front and center. So this is where also the preliminary statement applies. A preliminary statement can be a deep issue method. So how does it look like? Well, it simply is, for example, in this one that you're seeing in your slide, this circuit court in St. Clair County Criminal Division. Look at that. No? This motion presents the court with a single issue, and then he elaborates the entire issue and ends with a question. It's the same thing. So try to create a preliminary statement applying the deep issue method. Okay? Again, never use whether or not. Break each issue into separate sentences, which means in any class, dili ka mo diretso na whether or not he's guilty. You have to lay out the factual circumstances. That's why you have to weave enough facts and arrange them chronologically so that the judge can see how the problem rose, right? And keep the issue the paragraph short, like 75 words. This is a suggestion, no? And this is a suggested deep issue type of preliminary statements. Under Rule 25, again, what is the pattern here? There is a ruling, there is an application of fact, and then there is a question. Okay? Third, very simple, summarize. Class, don't put so much dates. Okay? But the rule of thumb is, if it's not necessary to understanding the issue, leave it. But if it doesn't add to human interest, leave it out. It's man a human interest. Things make things interesting for the reader. Okay? Don't put too much date, as I said. The fourth principle, class, is, as you already learn in your basic English in high school, introduce each paragraph with a topic sentence. And I provided here with a very good example of how not to begin a topic sentence. Tanawan ng weak opening sentence. So, diritso na siya giambak sa Section 40 of the National Electrification Administration Act, and then provides the limitations, etc. That is something na dili helpful because the reader, mura siya makurat ba na, manigikan, mas may context, ani. So the suggestion under the strong opening sentence column is that you try to provide the groundwork, why, the reason for this Section 40 or the context of this Section 40. So in the example, you lay out that the National Electrification Commission Act outlines the state's commitment, etc. And to meet this end, the Act provides a limitation of action. So see, there is a weaving of thought. And then I had then introduced ang Section 40. Okay? Now, Principle 5 is bridge between paragraphs. Again, this is basic writing. It means that you have to link paragraph 1, paragraph 2, paragraph 3 through use of connecting words, like pointing words such as this, that, those. Echo links, meaning anong echo links, class, is na-mention na mo ang word sa previous paragraph and you want to mention it in your second paragraph to re-echo it. And then the third is explicit connectives, meaning, it's really to words which really provide the transitions. Now, I did provide an example here. Di na kayo siya maklaro, no? But if you can look closely into this print screen, kaning mga arrows try to show you that the words actually link to the previous paragraph. So the reader's mind can connect it to the other paragraph. I just provide here with some examples of words, transition words, like also, in addition, besides, these things. To summarize, But kaning sequencing is very helpful. First, second, third, finally. Okay? We now have uh, principle 6. Again, don't have very long paragraphs. Generally, keep them short. Self-explanatory. Principle 7 is provide signposts. As mentioned earlier no, on the transitions, it's helpful if you provide the reader with signposts. So, may pasabot ng signposts. Well, for example, when you say there are several advantages, there are several elements, don't say several if there are four or three. So, say it, no? Write it down because kung mag-provide mo og quantity, the reader can at least expect how many things he would read. So this is an example. The next principle is unclutter the text by moving citation into footnotes. I think you understand this already. That's why I asked you to understand or use the citation manual so that you know how to cite and put them in the footnotes. Citations are interrupters born of a technologically impoverished world, which means that sa unang panahon, wala pa man ang Microsoft Word, so dito nila sa text gibutang ang citations which nadalara na practice until now, which should not be the case because it really sakit sa mata, right? Okay. Second to the last, we're very, very fast. Now, class, when you use quotations, like when I say quotations, like kanang gina-copy-paste yung entire jurisprudence or entire statute, common gina siya. And then you just say the statute reads in permanent part or the court stated as follows. Then quote, then sulat na rin tanan. Dili siya helpful. Why? Because, dili ka ka-signal sa reader unsa ni about ang case. So what is more proper is for you to provide a lead in. No? Say something specific and assert something. And these are very good examples like the statute specifies three conditions that a trustee must satisfy to be fully indemnified. Then I had a quote. And sada po din na example because it also applies the three. Kanang signal po muna there are three. Dili mo moingog several, right? So it signals to the reader that tulura iyang tanaw na point. So these are other examples. Do not do as one noted authority explained. Moingog yung dapat ito. Lintini laid out the differences, blah, 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 blah. Okay? And finally, the last. Going back to the middle part of the argument, where I mentioned about the legal premise, the fact, etc. This is just a reiteration. Be forthright in dealing with counter-arguments. If you want to write convincingly, class, please always ask yourself, unsa may i-object sa pikas party? Unsa may lang question? Manang importante na sa lawyer ma-develop pud ang imong ability to think outside the box and also to think how the opponent thinks so that you can formulate your questions and possible objections, and then you try to build an argument to counter that, right? So again, ayaw mong pagsalig na dili na lang nako na i-mention kay basing mas strengthen ang ilang position. No, you have to think of ways to counter their arguments. But the tip here is do not put too much length in supplying the answer, okay? So just the poor strategy of highlighting the opponent's argument is all too common, meaning don't put too much emphasis on counter arguing them. It's enough for you to point it out and provide why, right? Dili na mo work na argument. So Gardner actually provided us with this nifty tool for you to apply in the body of your position paper or your trial memorandum. Again, you start with the premise, the legal premise, then the facts or the application, then you conclude. Pero ayaw mo diha lang taman. You have to also raise, however, or may mo na, the respondent continues to argue that, and even if the respondent raises the issue of, or even if he argues that inana na possible objections na opening, then you have to answer, class. How do you answer? Same thing. You provide the legal premise, factual premise, conclusion, pero shorter na, no? Di na mo maghimog entire encyclopedia. And then further point, and then the clincher. The clincher simply is like a conclusion with an impact, right? Could be a creative way of closing an argument. So there you have it. These are the 10 principles that I am looking for in your trial memorandum or your precision papers. And I hope this can be applied also in your future legal writing, in your future courses when you reach next sem and beyond. Thank you. Good day to everyone.